done in red ink. It is of recent vintage. It has been put there after everything here has been filled out.
I heard something being said that something may have been added later. How do we know that it wasn't blotted out in photocopying?
Details of the verbal exchanges at the Supreme Court that triggered accusations of fraudulent conduct.
This is Top Story with Evans Mensah.
Top Story is brought to you by Bond Financial Services, your success, our passion. Belaka Mineral Water, the new generation mineral water. It's also brought to you by Lifebuoy, still 100% better germ protection. Also by Blue Rose Limited, Shelter for All, and Star Life Assurance. A case of fraud or a simple matter of lack of authenticity. That was the turn of events at the Supreme Court as a lawyer for the petitioners became entangled in a prolonged verbal exchange with all three lawyers of the respondents. The petitioner's lawyer, Philip Addison, vehemently challenged the authenticity of documents presented by the Electoral Commission. Now, the EC's lawyer had sought to tender in evidence some pink sheets purported to be those used in special voting in an attempt to discredit claims by MPP running mate Dr. Mahmoud Bawumia. That attempt was objected to, and it triggered heated verbal exchanges laced with accusations of fraudulent conduct. In the end, the EC was forced to withdraw the document. Listen.
Same pink sheet with different signatures. In effect, one of those documents must be a forgery. On the face of what they have submitted, one of them must be a forgery. We have had that coming from that side.
I don't see the difference between the first one you withdrew and this one. But if you feel that you are in your rights, okay, we'll rule on it one way or the other. If you feel that you can withdraw it, the tendering, and tender it through your own witness at the right time, it's up to you. Do I understand you to be insisting on your right to tender through him?
No, my lord. I will withdraw. I wish to be allowed to withdraw this exhibit.
You are supposed to say that because of the machine, everything you say should go into the machine too.
Yes. So I do not seek to tender this document.
So you are withdrawing?
That is so.
That's all.
We object to the tendering of this pink sheet. First of all, every writing on the face of this pink sheet is in blue ink, except the special voting, which has been done in red ink. It is of recent vintage. It has been put there after everything here has been filled out. And that is why special voting does not appear on any of the three pink sheets we have tendered in this court. We're questioning the authenticity of this document that has just been sprung on us.
I heard something being said that something may have been added later. How do we know that it wasn't blotted out in photocopying? How do we know that? It's a serious allegation. We should think the reverse.
We have had evidence in these proceedings, evidence from the witness, which shows that they have submitted before this court the same pink sheet with different signatures.
So in the end, the EC was forced to withdraw that document they had sought to tender earlier, and the judge gave a strict warning to them that if you do that again, you'll be abusing the judicial process, so you're warned. Joining me in the studio is spokesperson for the MPP legal team, Mr. Bawumia Sama. Also joining me on the line right now is Victor Kojoga Adaudu. Thank you very much, gentlemen, for your time here on Top Story. I want to start with you, Mr. Adaudu. You were in court today, and I'm sure you witnessed the turn of events when the EC's lawyer essentially had to withdraw that document. Was this allegation of fraud really something that was pre-planned? And if you had the case that was made by Tatu Chikata, he made that allegation of fraud today. What was that all about?
Thank you, Evan. Your line is so faint. Can you hear me?
I can hear you.
Yeah. Thank you. What we went today, it was when the lawyer for EC wanted to tender a document. Hello?
I can hear you, yes.
Yeah, wanted to tender a document which is an exhibit and has been tendered already by the petitioners. So it was during the cross-examination to quiz the witness on a matter pertaining to that particular exhibit that he tendered, that he brought out the original document that he wanted to tender. I think it was there the counsel for the petitioners said that they were objecting because they have seen a writing on the document which might suggest that it was a recent writing, and that's where the counsel for the president also said it's a serious allegation that was being made. And I think in addition to that, Mr. Tachisikata also said, yes, there were documents that were tendered before the court that were duplicates. Some even were duplicates with different signatures which look forged. So that's why he said on the face of it, it looks like a forged document. I think the basis is that the document he was intending to tender or bring was to challenge an assertion he had earlier made. I think that is the import of that matter.
Is that your interpretation? Just a bit, hold on for me briefly. I've been joined in the studio, as I announced earlier, by Mr. Bamiasoma. Is that your interpretation of what happened?
Absolutely more critical than that. There are two clear situations at stake when it comes to pink sheets, original pink sheets, being tendered in court by the EC. First of all, in principle, the Electoral Commission has refused flatly to bring these pink sheets to court, either as affidavits or by order of the court. You will recall that an application was made for them to bring them in as a public organization funded by the taxpayer in custody of public documents in dispute and tender them in court at that time. They refused flatly. Now, when they had the opportunity to respond to the petitioner's case by affidavit, they didn't exhibit one single pink sheet to counter the affidavits. They exhibited a 4-page affidavit with 2 or 3 attachments, photocopies of pictures from the register. So in a sense, it was almost as if the EC has been hiding these pink sheets. So in the first instance, you spring a pink sheet, 1 copy at a time, and say this is the original and I want to tender it through the hostile witness, the petitioner, who doesn't own that document.
And if you heard Tachisikata, he made the point that there's a possible case of fraud that original document can cure.
No. Why didn't he bring them all in to cure them? Or why didn't he attach them to the affidavits? That is the question at stake. Because at this point in time, we haven't seen them. There is no basis to believe that it is about to cure anything. And in particular, when you raise the question that the law, that's the consequential on the first one, the law about special voting clearly does not talk about pink sheets. And he was trying to introduce a second pink sheet to confirm a position about special voting, which was flatly denied by the petitioner. And yet he wanted to push that in through the petitioner and compel the petitioner to commit to that document, which the petitioner under any circumstances could not commit to. So that was the question. If you have a set of pink sheets which have been used for special voting, what stops you from exhibiting all of them as part of your affidavit evidence?
Mr. Daudu, another key issue that came up today, essentially, was the accusation that was leveled against your lawyers that indeed, in certain cases, they were even crying more than the bereaved because the EC's lawyer was on the floor making arguments, and they were sort of making arguments to back him. And you heard the NPP's lawyer, Mr. Addison, make the point clearly in court today that that cannot be allowed because indeed that's not their case. It's the case of the EC. The suggestion was that all of you were sort of ganging up against one person.
Yes, I think the court actually made the lawyer, the lead counsel, to understand clearly that his argument was flawed because they are parties to the suit. And anything that would affect this suit, they have the opportunity to talk to it. In a cross-examination or in evidence, any party to the suit has the right to objection, has the right to cross-examine, has the right to lead evidence. Even if the matter does not go to the root of that party's case, you cannot say the party cannot speak to the issue. And that is why Mr. Tatutikata jokingly said, my locus in this matter is that I am the lead counsel for the third respondent. They are part of the matter, and any decision in this matter will affect them, so they have the right to speak to it. Let me quickly react to what Yawa Bobby was saying, that
please do.
The document that was intended to be tendered is a public document, official public document. Now, if you are going to court, you do not rely on the evidence of your opponent. You rely on the strength of your case. So if he chooses that they will not bring any affidavit, they are just to come and assert that we are innocent in this matter. We have not done anything. It is not as if they would have to carry all the evidence and bring it to court. No. The respondent don't have anything to prove.
But if I heard the president of the panel correctly, the mere attempt to do that is, as he put it, an abuse of the judicial process. And if he did it again, he will be dealt with.
No, you see, what the order sought to be done when at the direction stage was that file any witness you intend to call, file affidavit evidence. That means what the witness is coming to say. And they gave opportunity to the parties to be in the box. So if you come into the box, that is why the first respondent, essentially the exhibits they brought, we cross-examined them on their own exhibits and documents which we thought was important. We tendered it. That is why the EC lawyer is also sending documents he thinks is important. It is what he was talking about is not to be using it single. He can put it in badges. And documents that he can put in badges, he can bring it.
It appears Mr. Babian Sama disagrees with that.
The court was very clear. The court says it is the EC's own documents, and those documents cannot be tendered through the petitioner, the witness at that point in time, who was a petitioner. And that if the EC so wished to rely on those documents, it could come to court and file them on its own behalf and tender them through their own witness at the appropriate time. And you see, this case at some points has been challenged by procedure.
That was the case today.
Yes, it's sui generis. That means it's completely fresh. It's new. We haven't been this way before. We have rules to govern it, but the rules are not complete. That's CI 74. And therefore, we are being compelled to import bits and pieces of the normal rules. But this is not a normal case. So if you take the rules that are normal, that means it could drag out forever and ever, as it were, in terms of the normal process of cross-examination, in terms of how we position ourselves as the plaintiff and the defendant. In other words, if you import standard plaintiff-defendant relations into this matter, we are going to run into lots of problems. That's why the court defined the mode of trial, come by affidavit. And that everything you have to say, either in response, in your own defense, or in reaction, counter-reaction, put on paper, and don't surprise anybody. Then the process goes on.
Mr. Daudu, final question to you briefly. What are we learning so far in terms of the unprecedented nature of this case and the many objections that had come, and the judges will have to overrule or indeed rule in somebody else's favor? Are we learning any key things that we didn't know before this case started, looking at its unprecedented nature?
Yes, you see, Iman, just to say that looking at this case, it is the first instance that it has happened in our history, and it is two different procedures that we are looking at it. If you want to look at this in a proper term of a petition, it will be an only affidavit. But the CI 47 also mandates how the process should go. And it is not entirely true to say that you cannot tender your document through the opponent. You can tender your document. That's why I'm happy he said that if we want to import the normal procedure into it. So I'm sure we will fine-tune it, and as we go along, we will define. And I think the pace we are moving, if you look at it from the day Mr. Tonita started, I think we have made progress.
Good for democracy, isn't it? Thank you very much, Mr. Daudu. Final words, 30 seconds just before we wrap up.
The court is making good progress. I like the demeanor of the court. I like the way the court is beginning to take control of the procedure and appreciating the challenges at stake. I think we are comfortable. I think this case is going to be a landmark not only in Ghana but in Africa.
Thank you very much, Babia Samoa. He's the spokesperson for the MPP legal team. On the line earlier was Mr. Victor Kojoga Adawuda, who is the member of the NDC legal team. This has been Top Story. My name is Evan Spencer.